Welcome to InstaLegal. The question for today's discussion is, what is the effect on motor accident claim in case of death of the claimant? Now we are going to discuss this question by way of a recent decision of the Supreme Court in the case of the Oriental Insurance Company Limited versus Kahlon, deceased through LRs and another. Now this decision was rendered by the Supreme Court on 16th August 2021, where the questions involved were whether cause of action would survive on the death of the injured person if the death was caused not due to the accident but in natural course. The second question, which is relevant for our today's discussion, is what would be the loss of estate mean and what items would be covered by it. Supreme Court dealt in both the issues in a very great details. Before we understand the decision which has been rendered by the Supreme Court, let us first understand the facts of the present case. In the present case, the original claimant was declared to be 100% disabled in the motor vehicle accident and he had filed a claim for compensation. The tribunal granted only a meager amount of rupees 1 lakh with 9% interest. Being dissatisfied, the original claimant himself filed an appeal before the High Court, and during the pendency of the appeal before the High Court, unfortunately, he passed away. After the death of the original claimant, the wife had also passed away. The unmarried daughter, who was the only legal heir, aged 21 years at the appropriate time, was substituted in appeal before the High Court, who had subsequently enhanced the compensation to rupees 37,81,324 by taking into account his annual salary with future prospect, applying the multiplier of 11, including pain and suffering, attendance charges, etc. Against the enhancement by the Honorable High Court, the insurance company came in appeal before the Honorable Supreme Court on the ground that the cause of action being personal to the injured abates on his death, which was not caused due to the accident. The legal heir is entitled only to such compensation which forms part of the estate of the deceased. Loss of salary, future prospects, pain and suffering, along with attendant charges, do not form part of the estate of the deceased. After hearing both the sides' arguments and after looking at various decisions of the Supreme Court and the High Courts, the court subsequently held that this act is a beneficial and welfare legislation. Section 166(1) Clause A of the Act provides for a statutory claim for compensation arising out of an accident by the person who has sustained the injury. Under Clause B, compensation is payable to the owner of the property. In case of death, the legal representatives of the deceased can pursue the claim. Property under the Act will have a much wider connotation than the conventional definition. If the legal heirs can pursue claims in case of death, we see no reason why the legal representatives cannot pursue claims for loss of property akin to estate of the injured if he is deceased subsequently for reasons other than the attributable to the accident or injuries under Clause 1C of Section 166. Such a claim would be completely distinct from personal injuries to the claimant and which may not be the cause of death. Such claims of personal injuries would undoubtedly abate with the death of the injured. Meaning thereby, the Supreme Court said that the legal representative in the present case, being the daughter who subsequently got married, can pursue the claim for loss of property akin to the estate of the injured. But what would this estate of the injured include is what the question was discussed thereafter by the Supreme Court. The Honorable Supreme Court, after discussing various decisions of the High Court and the other decisions rendered by the Honorable Supreme Court, observed that while the claim for personal injuries may not have survived after the death of the injured unrelated to the accident or injuries during the pendency of the appeal, but the claims for loss of estate caused was available to and could be pursued by the legal representatives of the deceased in the appeal. Further, the court, after taking into consideration various decisions of the Honorable Supreme Court and the other decisions of the High Court, came to the conclusion that the loss of estate would include expenditure on medicines, treatment, diet, attendant, doctor's fees, etc., including income and future prospects, which would have caused reasonable accretion to the estate but for the sudden expenditure which had to be met from and depleted the estate of the injured subsequently deceased. Subsequently, the court said that the compensation under the head pain and suffering being personal injuries was held to be unsustainable and was disallowed. So the High Court order thereafter was modified to the extent that the award which was given for the pain and suffering was set aside and another 1 lakh rupees was given towards the medical expenses. The reassessed total compensation was calculated to be 28 lakhs 42,175 with the interest of 9% as already awarded by the Honorable Tribunal. The loss of estate will not include the personal injuries but the other heads like medicines, treatment, diet, attendance, doctor's fees, other expenses, future prospects, etc. would come under the definition of loss of estate. Plus, only for the claim of personal injuries, the claim would be abated. But for the loss of estate which has occurred due to the death of the person during the pendency of the proceedings would not subsequently abate. Thank you very much.